Ladies and gentlemen, a pleasant evening is wished to all. We are particularly pleased that as many of you stakeholders in the use of music have been able to make it to this evening's public consultation on music licensing. We at the Intellectual Property Office and the Ministry of the Creative Economy have seen it fit, at least ahead of the Christmas Carnival season, to address this issue that has become pressing. I will not take up any more of your time. We will start with brief remarks by the Registrar of Intellectual Property, Ms. Jan Williams, and she will follow with a brief presentation. Ms. Williams.
Good evening, everyone. I know that it is late in the evening and some of us wish we were already home doing what we like to do. But I want to thank you all for coming out and for us to have this conversation about music licensing. It has become a very topical issue. Every now and then we have a situation where the talk about ECHO and what ECHO does and what ECHO should do and what ECHO should not be able to do. These things come up in the public, and it is very obvious to us at the Intellectual Property Office that this issue needs some public awareness and education. So rather than talking about it when there is a crisis or when something has gone wrong or somebody has been sued or something like that, we want to give the public an opportunity to learn about this issue before there is some crisis. So we're here to talk about music licensing, and I have to mention that this consultation has been commissioned by our learned Attorney General, the Honorable Garth Wilkin. He shared the view at a press conference that we had on the 13th of October that the procedure or he was not pleased or he was not satisfied with the way that ECHO was operating. He said there was room for improvement, and we realized that there has been some hostility in this area. So we want to make sure that everybody understands and that we're clear about what should happen, what can happen, and to hear from you as well what needs to happen or what you would like to happen. If there is any way that we at the Intellectual Property Office can assist, or the Ministry of the Creative Economy. Our department, along with that ministry, are jointly facilitating this session here this evening. So when you heard about music licensing, did it sound strange? I like interaction, so feel free to interact with me. It may have sounded strange, but I am sure many of us heard talk about the Get Rid of Them song. And somebody complaining from St. Vincent that, this song was being used in the campaign here in St. Kitts and Nevis without permission. And that seemed to have generated quite a bit of controversy and conversation here in St. Kitts and Nevis. But again, perhaps some people don't understand why you would need to have permission or why that is even an issue. So that's what we're here to address today. So why do you need a license for music? Now, we have to start at the beginning. Now, when you hear a song on the radio or you stream it wherever you stream your music, lots of times we have this impression that a song is owned by the person who sang it. That's not necessarily the case. A song is owned by the person or persons who composed it, composed the lyrics, composed the music, the melody, the composers of the song. that's separate and apart from the performer of the song, although the performer could also be a composer if they wrote the lyrics themselves or they did the music. So when we're talking about ownership and permission, we're talking about the music composers. Also, you may have heard the term of a masters, and artists talking about their owning their masters. But what is a master? The master is the original sound recording of the song. When they got into the studio, the first time the song is actually performed and recorded, that recording is called a master. Or you might sometimes hear it referred to as simply a sound recording. So the person who owns the sound recording is usually the publisher. And so those are the people who we are talking about when we're talking about ownership of music, the composers and the publishers. That's going to be important. Now, under the Copyright Act of St. Kitts and Nevis, it is a piece of legislation that has been in force since 2002. So it's not a new piece of legislation, but the question is, has it been enforced? And the answer is largely no. Although some people, of course, have been using it. The Section 9 of the Act speaks to a number of acts or activities that an owner of a song can do. So, for example, the owner of a song, and remember who we said are the owners, the owner or owners of a song have the exclusive right to copy the work, issue it in public, adapt it. So, for example, an example of an adaptation is doing a remix. So you took somebody's song and you changed some of the lyrics, or you changed the beat. You changed it into a different format. That's called an adaptation. And these are some of the activities that Section 9 of the Act says only the owners of the works, in this case music, can do. Among these acts at Section 9C is the exclusive right of the owner to have the music played in public. That is a standard right, which is called the right of public performance. So it means then, if I wrote a song and Nicola did the music, we are the only ones who have the right to play the music in public. Now, all of us probably have the ability to play the music in public, because if we put our song on iTunes or YouTube or one of these things, then you could simply play it. However, by law, Section 9C of the Copyright Act, only the owners of the song have the right to play their music in public. So what does this mean? This means that in order to play the music in public, you have to get permission to do that. And when we're talking about playing it in public, we're talking about streaming it, we're talking about playing it through speakers, any sort of playing or performing of the music that is done in a place that is accessible by the public. So you will find that tonight we invited persons from supermarkets, persons from banks, persons from all sorts of radio stations, all sorts of different things, because at some point in time, all of you are playing music in your establishments or with your initiatives. Event promoters, we also invited people who do karaoke sessions and things of that nature, because we want you to understand that by law, And if you ever question where the law came from, it's Section 9C of the Copyright Act that says only the owner has the right to play or perform the work in public. Now, having understood that, it's important to let that digest, but understand then that Section 31 of the Act says that if you don't get permission to do any of the acts, including playing the music in public, then you could be liable for copyright infringement. That would be a suit from the owners of the music, or in the case of where ECHO comes in, if they represent the owners. Next slide. So, as I said, you need to get permission to play music in public. And I'm talking about music, but I mean any kind of copyright work, which extends to books, art, music, dramatic productions. All of these things fall under copyright, but tonight we're talking about music specifically. So when you're playing music in public, you need to have the permission of all the owners. So even though I might be the one who you hear on the radio singing it, you come to me and you ask me for permission, I might not be the owner. Or secondly, I might, we blacked out again, or I might not be the only owner. So you would have to get permission from, in the example of my song, you'd have to get permission from me, and you'd have to get permission from Nicola as well. So all of this could be cumbersome, of course, because if you're having an event and you're playing, you're not going to play one song, you're playing multiple songs. So what creators do, or the composers do, is that they join these groups called collective management organizations, or CMOs. And they give those CMOs the right to grant permission on their behalf. So rather than coming to me and Nicola and anybody else who was or is an owner, you go to, in the case of the Eastern Caribbean, you go to ECHO and they give you permission to use the music on behalf of the people that they represent. I'm sure they will go into more about who they represent and how their representation works, but I'm just giving you the general information as to how that would work. Now, how CMOs operate, like I said, they give you the permission and you pay a fee for that permission. Those fees are collected and pooled. ECHO, or the CMO, takes their administrative fees out of that pool, and then they distribute the remainder to the persons whose music was played. Now, it works well if fees are being paid. So if there is no pool, then nobody is getting anything, no royalties. Those payments that the artists then receive from their CMO, those are called royalties. So if there is no pool, there is no royalties. So if 3 people are paying out of a group of maybe 300, then what they collect from those 3 people is what they're going to administer. So it's important that we understand that this is how songwriters and music composers and publishers make their money. It's like a payment for the value that they added to your establishments or your events. Now, I know there's a lot of people feel funny about that, and I promise you this is a space where you guys can ask questions. This is the opportunity to ask any question, and we will address it There is no penalty here. There is nobody coming down with a big stick or anything like that. That was a term that I think someone used when we had the press conference. There is no big stick. This is the opportunity for you to understand what is happening and why this is happening. So feel free to ask questions. Next slide.
Can I ask the first one, please?
Sure.
And I'm representing
Could you come by the mic? The mic here.
You're not hearing it?
Well, we want to make sure the people on the live stream could hear you as well.
Oh, I'm going live?
Yes, it's being streamed.
No, I'm speaking specifically to the church, which is my business. I'm a priest of the church. So we've been using music, hymns. We have a hymn book called Hymns Ancient and Modern, and that says a lot. So if we are using the hymns that have been there from time immemorial, who do we pay?
So a song or any kind of copyrighted work has copyright for as long as the writers or composers are alive, plus 50 years after they've died.
So if they're dead, what happens?
Dead and 50 years have passed, then the music goes into what you call the public domain. When songs are in the public domain, and I don't mean like YouTube and able to be accessible, but when we're talking about the public domain, that means that you can use the songs without having to ask permission.
Well, I think we're
So, so that would be covered if all of the songs that you're using are in the public domain, meaning that every composer of each song that you're using has been dead for at least 50 years.
Okay, so we cover that.
All right. So, I mean, we sing more gospel, more modern contemporary songs if those persons a lot of instances are still very much alive. And so it is a question of whether you're using any copyright protected material. And if you are, then, we could have a conversation with, well, not we, but you can have a conversation with ECHO. However, under the law, there is a provision that if you are operating solely for charitable reasons, then you are not guilty of copyright infringement. However, you may still be subject to paying a very, very small license. So again, it's a conversation that you have. You let them know what songs you're singing, what songs are the concern, and you go from there. Now, we were talking earlier about paying for the license. And a lot of people have said, we've seen the comment of, well, if, for example, in the case of an event promoter, if you've already paid for the artist to come to St. Kitts to perform, and you've already paid them the fee, then why do I still have to pay ECHO a licensing fee on top of that? Now, the answer to that is because it falls in the fact that those fees are for two different purposes. So a performance fee is the fee that you pay the person who is performing for their dance moves, their ability to sing, their ability to interact with the crowd. And that fee, it usually is held by the performer and his or her manager, depending on what contractual relationships they have. That is for the performer. But bear in mind that the performer, like I mentioned earlier, might not be the owner of the song, because maybe they were not involved in writing the lyrics or writing the music or anything like that. They were just given a song to perform, and the fees, the licensing fees that are collected by ECHO cover the public performance license. So that is the fee for the right to play music in public. That is separate and apart from performing a song in public. If the performer is also a creator, they would still be entitled to that payment. They would still be entitled to receive their performance fee and also their royalty payout from Echo when the monies are distributed based on their song being played. So they're being paid for one, performing, that's their performance fee, and then they get something back for the value that they added to your event by you being able to play their music in public. So they get paid twice. Some people call it double dipping, but it's like if you own a taxi and you have a driver, you get something for ownership of the car, somebody being able to use your car, and that person also gets something for driving. Is that clear? Is that understand? Okay. Okay. Next. So my presentation is pretty much that, so you understand the background and the basis for how CMOs operate, and in particular Echo. So if you're playing music in public, if you're streaming music, broadcasting music, you have an event and music is being played, you're organizing events for people and music is being played. For example, if you have a bar or a restaurant and you hire a DJ, as the owner of the establishment, you may also have to pay a license to cover the DJ playing music. So that's something that you'd want to bear in mind as well. So playing music in public, you have to get permission. And to get permission, you need a license. And to get a license, you either have to go to every single owner or composer of the music that you use, or you get what is called a blanket license from Echo. So you could take the option to go to every single person if you want to, but I'm pretty certain that will take you a lot of time, and time is money, and we don't have neither to waste. So we want to make sure that the CMOs are there to ensure that your job of getting permission is a lot easier. Yeah. Yes. Yeah, come by the mic. Would prefer. Fons, you're fine. You're fine.
All right, so here's my question. If I'm doing an event and I hire Sugar Band or Mention, and Mention is an Echo artist, and Mention makes no mention that he's an Echo artist in our contractual arrangements, although he's performing his own content, because based on what you said, we would need permission from either Echo or the content owner or the artist. So if I got permission from the artist for him to come and perform his own content, then why do I need to go to Echo? And wait, if it is that Echo then comes and say, hey, you have Mention gave us the right to collect royalties on his behalf, right? If that is the case, then who is at fault? Because technically, Mention didn't tell us about Echo. So in a case like that, I would like for you to explain what is the penalty, who is at fault, is there a procedure? Because from what I understand, every single agreement that is signed between Echo or CMO and an artist or the original content owner has to disclose in contract if they're making any contractual arrangement with a third party. So that is my question.
The responsibility to disclose to a third party is not by law. That is something that they could be subject to based on their arrangement with the CMO. But one, by law, they don't have to disclose that to you as a promoter by law. I don't know if contractually they're bound by some other prerequisite, for want of a better word, that says they have to disclose that to a promoter.
So that would mean that there is a fly in the law?
Not necessarily.
If it is that I can enter into a contractual arrangement with the provisional content owner, and you're saying that he has not the rights to go to also collect on his behalf, and he's performing his own content, then how do I still have to echo and still him?
So it's back to the same example that I use, where it's two different things. Even though it's coming from the same performance, you're getting paid for two separate things. Just like if you book a flight with American Airlines, you pay for your seat and then you also pay a tax. It's from the same flight.
So there's a difference between technology of American Airlines. If I go to mention and hire mention, I don't know mention has affiliation to Echo. So if Echo comes from this side and say, hey, I'm assigned to collect royalties from whatever performance mention is doing. How do I validate that mention is even connected to Echo? If
Well,
there is no mention of it.
That's an echo question. Whether there's no responsibility. Let me say this now. There are no regulations currently speaking to how CMOs operate in St. Kitts and Nevis. We have, and not just we in terms of the Intellectual Property Office in St. Kitts and Nevis, but regionally, we recognize that this is a problem because people are not fully au fait with how CMOs are supposed to operate. They think sometimes that, CMOs go too far, or they're not sure how they're supposed to verify this information. How do you know that this is a legit organization? People have those questions. So regionally, there is a project that is sponsored by the World Intellectual Property Organization to draft CMO regulations. We just did our fourth review of these regulations, and we're hoping that by next year we could have a new Copyright Act which includes these CMO regulations, including things like having requirements that artists disclose their partnership or membership with CMOs. But right now, there is no requirement legally for them to disclose it. However, this is a right that these people have, that mention would have just by law. So it's something, I don't think there's anything wrong in asking for verification to make sure that you're paying the right person if you're not sure. So I think that's something that we could do more of, and I think sessions like this, where people get to learn more about ECHO and understand how they operate, would help with a lot of the confusion that naturally exists when people are not aware of how something operates. The other thing that I want to mention about your example is that you may have contracted Mention to perform his content, but Mention may not be the only owner of the music as well. So he may write his lyrics by himself, but he may not be the only person responsible for creating the music or doing the beat. So if you're paying Mention his performance fee, then those other people who contributed to the composition of the song are not getting anything because they're not performing on the stage. But their work is being used and their work is adding value to your event. So this is the payment that would be due to them that ECHO collects. Is funds quiet? Yeah, I think ECHO could perhaps explain, and I believe that they would have the grand the bulk of the presentation here this evening. So people who play music in public, you need to get the license. Persons and entities who play music in public, these includes event promoters, restaurant, bars, hotels, a list of people. Now, failure to obtain a public performance license can result in a civil suit by the owner or penalties for the offense of playing musical work in public, knowing that it is copyright infringement. So if you don't get a license and you know you're supposed to get a license, you can face civil suit or penalties for an offense, and you can check section 46.3 for the specificities. Like I mentioned earlier, if you need a public license, you are free to go to every single owner of copyrighted work, or you can go to ECHO, who operates in the Eastern Caribbean. In every region, there is at least one CMO. So ECHO operates from the Eastern Caribbean. You have COT in Trinidad and Tobago. Trinidad and Tobago actually has more than one. COSCAP in Barbados. So these organizations exist to administer the right of playing music in public. And they have what they call reciprocal arrangements, which means that if we're playing Patrice Roberts or somebody else in Trinidad, Mashal Music, what if Mashal is registered with COT, then ECHO will collect on COT's behalf, and then they pay to Mashal. Yes?
Yes, good evening. I have a couple of questions.
Sure.
The first one is, what teeth does the CMO have in the international arena? And I'm not just talking about the Caribbean. I'm talking about the UK, the US, Australia, those kind of places. Does the CMO have reach in those areas? Because a lot of music comes out of those markets as well, not just local or the Caribbean. Secondly, in terms of radio station broadcasting, everyone is fully aware that a radio station has tens and tens of thousands of artists. Now, you rightfully said that it'll take time to go through contacting all these artists. Is it a one-time fee? Is it an annual fee? I mean, how do you quantify a fee, knowing that a radio station is going to broadcast on any given day at least 500 to 1,000 songs, different artists? Is there a measuring stick?
That's your last question, because those are two perfect questions for ECHO.
Okay, I'll have you back.
Yes. Yeah, but in relation to the teeth of the CMO, like I said, there is at least one CMO operating in every region. So the CMOs that fall under there's an international grouping called CSAC. So those CMOs that fall under CSAC have what you call reciprocal arrangements. So even though ECHO administers in the Eastern Caribbean, let's say they have a reciprocal arrangement with ASCAP in the US. So if you want, you're playing Beyonce's music, then ECHO could give you permission for that because of the reciprocal arrangement that they have with ASCAP and with the other dozens of CMOs that operate around the world. So they have their network because they fall under an international grouping. So they're able to give you permission for works that are not based in the Eastern Caribbean. I'll let ECHO address the question about the measuring stick for fees and whether it's a one-time payment or things of that nature. But that is the basis. I just wanted to make sure we gave you all the legal basis for music licensing. It's important because we're realizing more and more that people are becoming more litigious in the region and internationally when it comes to music and copyright. And it's easier for you to get a license and have that, use that as your defense if there's ever a claim for copyright infringement against you, as opposed to not getting the license and then somebody making a claim for copyright infringement. The damages will be far, far, far more extensive. So this is us just trying to let you all know that it is becoming quite litigious in the region. Not just because we're in St. Kitts and Nevis, we feel like people don't know us and people don't pay attention to us, but these things are becoming more and more of an issue from international players and also regional and even national players as well, who are realizing that they have these rights under the law and their music is adding value to your establishments and your events, and they're not getting anything back for that. So if there are no more questions, yes. Mm-hmm.
So, as you stated, Jihan, there are so many entities that play music in public, from churches to banks, supermarkets, event promoters, music festivals, carnivals, etc. How does ECHO determine who to essentially request fees from? Because I am pretty sure that 90% of the entities that you listed previously do not pay ECHO fees. So how does ECHO determine, I'm going to go after this event promoter, but I'm going to allow this event promoter to get away? I'm going to go after this bank, but I'm going to let the supermarket get away? Like, how does ECHO determine who to request fees from? And is there like a scale? Like, there's a bar association fee scale. Like, is there a scale? Like, how does ECHO determine, okay, the music festival is going to pay this, but the event promoter is going to pay that, and the radio station? Like, there is so much information that needs to be publicized regarding ECHO, and I think that it is, I mean, it has started, but I think it is, for want of a better word, unfair for even me as the chair of National Carnival. I don't know the fine print regarding ECHO. So if I don't know it, I'm sure 90% of the people don't, and so therefore it should not start when an event promoter is having a function. It needs to start, as you said, now, and there needs to be a series of stakeholder meetings, whether it is with registered event promoters that fall under National Carnival, major FET promoters, banks, supermarkets, so that people are aware of exactly what or who ECHO represents and the role of ECHO. So it is fitting that the sessions, the public stakeholder forum begins and has begun, but I think there still needs to be a lot more discussion that needs to be had so that people are fully aware of exactly what ECHO is and who ECHO represents.
Okay. Thank you so much for that. Shannon, yes, go ahead.
Just to piggyback on for what Shannon just mentioned, I would also like to know, this may be a bit unorthodox, however, considering that ECHO is an independent entity, I would imagine, I would like to know, one, do they have to pay taxes? Two, are they registered in St. Kitts? Or do have an established business here? Three, are they even regulated just as everyone in this room is about to be, based on, when I walk in here, I sense a tone automatically that, hey, you got fees to pay. But there's a bit of ambiguity in all of this, and I do feel that there should be an amnesty period before we could even start to stick people for fees to pay, where there is proper education and where there is also fairness, because rightfully so, I can say for a fact that some people are targeted whereas others are not. Now, if you are operating in the best interest of all your artists and everyone that is registered with you, there shouldn't be a loophole. It should be everybody. But to me, it seems that some of these CMOs choose to target events or stakeholders who they feel may have the biggest payout. And that doesn't make it fair. There's going to be a new technology release soon called NFTs, and I think that it's going to be a very unique situation to see the role that CMOs would play, because artists have also complained that after collecting these lump sum in blanket fees, technically, you don't know how much ECHO retains for themselves, and I would like to know that as well, as opposed to how much is paid out to the artist in the end. So, the next thing, I mean, it's a series of things, but I know that it would resonate. How do we ascertain that the fees are being paid to the artists? And the other thing is, technically, how do they set the rates that are to be paid? And does this go through government? Because different territories, in St. Kitts, for example, the cost of entertainment is relatively cheaper than other places. The cost to bring, I don't want to say, but the cost to bring Buju here, for example, maybe 300,000. The cost to bring him in Antigua is the same 300,000. The difference between Antigua and St. Kitts is 100K population as opposed to 50,000, right? But we are still paying the same fees. So at the end of the day, how are these interests or tariffs calculated and determined?
Okay. Well, again, questions for ECHO. So I think, but what I will say is that we have definitely been trying to assist in the public awareness initiative, because technically this is, the ECHO is acting on behalf of their members. As the Intellectual Property Office, our responsibility is to make sure that people understand the law behind copyright. But ECHO is a separate entity, registered as a NGO, that is acting on behalf of the people who sign up with them as songwriters or composers. So I've noted, and I know we have some ECHO representatives from head office who will join us. I think they're already on the live, or they're listening, so they'll be able to answer questions such as how are the fees, what's the scale? I know there's a tariff schedule, so again, I'm hoping that they would at least tell people where to find this information so that people can act accordingly. The Attorney General did ask ECHO to consider somewhat of an amnesty period or a discount or something of that nature. So I believe that they will have some sort of announcement or proposal in relation to that. So hopefully we get that tonight. And I really want to impress on our representatives from ECHO. I'm happy people are asking questions, because these are the questions that we receive, and we're not in the position to answer on behalf of ECHO because we're not ECHO. So we want to make sure that these questions that are being asked here tonight are answered. Yes.
Good night, everybody. So I understand some questions, kind of for ECHO to answer. Mm-hmm. I have one that maybe you could help us with, like with the police.
With the police?
Yeah, and do you know what the police's position is on this? If we're talking about legal ramifications, we're talking about people's rights being infringed, I would imagine that at some point, police may be put in a position to either address a situation, mm-hmm. right? Also, the issue that's being raised in terms of who ECHO chooses to approach and stuff like that, perhaps we could employ something that is being done in some of the other territories, where when persons apply for their licenses to be able to either hold public functions, to get their broadcast license, one of the prerequisites is to provide your blanket license. In that way, it's not an issue of this person is being attacked by the CMO or that person or this radio station. In order for you to operate in the first place, this is a prerequisite. If there's an understanding that this is mandated by law, mm-hmm. then I think that may be the easiest way to deal with it.
ECHO was here some years ago and did have meeting with the High Command of the police. Our office has since then had meetings with the High Command of the police, so the police are aware of their role in all of this, and that's as much as I can say about that. I think at this time then, because since most of the questions are focused on information from ECHO, I will pass over to Nalzi. You have, or it's, I don't know how you all are. Yes. Okay.
Okay, I'll address well, my name is Winaldrine Francis, the Director for St. Kitts and Nevis. Sorry about that. And we also have the ECHO agent, which is Grace Richardson. Waiting online, there's Mr. Keen Cotter. He's the officer in charge and the membership officer, as well as Vindra Kazaba, who is the licensing support officer. But I'll begin by addressing some of the questions that came to us. One by Ms. Hawley asking, no, let me start with the gentleman first, with the radio station. You asked how we monitor. We use a service called Vericast, and by extension BMAT, and that service is used internationally. And basically what they do is they monitor each play from your radio station via streaming link, your streaming link. It can also be set up in-house, but we normally generate our data from BMAT, via that means. You can also, which is an option, submit your logs every day. All the music that you've played, that is another option that you could adapt to your daily routine, but it is not feasible. So normally we take the responsibility, and of course there's a fee, to monitor your music via BMAT. Does that answer your question? No. Okay.
That was not my question.
What's your question?
My question was twofold. How's the fees? Is it a one-time fee?
It's a blanket license, yes.
Okay, so, and then, I mean, how does it, I mean, she answered the question, the part about the reach. I understand there's similar CMOs.
Right.
Everywhere. Who determines what that blanketed fee is?
Well, there's a tariff. The tariff is a general tariff that is used with all the Association for Caribbean Copyright Societies. There's a base, and the tariff is determined by, well, it's categorized basically. So the tariff for broadcasting is different from a live event, or for stores, or restaurants and bars, etc. There's a separate tariff. So the ECHO tariff is actually available online. It can be found on the website. It's always been there. It's on echorights.org or echorights.com, and you can actually peruse that document online.
Okay, in terms of NTRC, you're issued every year a license. You pay a license to broadcast, and you pay a license. Well, that's the NTRC. You pay a license for the frequency.
Right.
So let's talk about the broadcast. I mean, I recall when I filled out the application, on that form they asked about what are you broadcasting? Music. Nowhere did it mention anything about CMO or any ECHO or anything. I am paying for a broadcasting license to broadcast music.
Right.
Right. So is there any connection? I'm not speaking out of it. Is there any connection with, maybe ECHO needs to get in with NTRC, so when this happens, when I have to renew my license, it can be seen on a form that says, well, you're not just playing your fee. Grace, Grace, are you hearing me? You're helping the mic. Oh, you're gonna pass the microphone. Okay. Grace is my friend. I am concerned because, like I said, I just recently renewed my licenses, and I paid a heavy price to NTRC, for the broadcasting. Why do I have to pay for a broadcasting license if my business is to broadcast music, but I have to pay a license to play the music. I don't understand.
They're two separate things. So you're paying to have a frequency, you're paying to have it transmitted, but the license covers the usage, the permission to use it. To use the music. So for right. So if I use the example of a vehicle, you may have paid the license to drive the vehicle, but if you wanted to rent it, of course you may have to go to the government to have another type of license in order to have a rental service. But it's still your vehicle. You still have certain things that you have to pay, maybe to license it, to make sure that if you hit someone, they're covered, or their vehicle is covered. There are different things that is attached to anything. So this is just one of the things that is attached to what you do.
Can I add? When ECHO came in 2018, we also spoke to the then Attorney General about the same issue, NTRC, and the licensing of music. So that was brought up before. But we're at this point and nothing has been done about it.
Truth. Okay, so the other question. How does ECHO determine who to approach for a license? Okay, first of all, ECHO does not target anyone. Some individuals may feel differently, but I can say that we don't target anyone. ECHO would communicate or reach out to different individuals about obtaining a license. Sometimes these requests are ignored, and after a certain time, we decide to take further action. And this is on behalf of of course, the rights holders of the music being infringed on. The next question, again, I spoke about the tariff. Yes, ECHO is registered in the Federation as a non-profit organization, so yes, we do have the right to operate in St. Kitts and Nevis. Did I miss any question? We could. The tariff will also, will there be a presentation on the tariff in the near future? So outlining, the different categories and what is worked out, as well as the introductory rate for the Federation. Mm-hmm.
A question was asked in relation to that I find the loophole by. So a question was asked in relation to how do we know the money is being paid to artists, how we know how much is held back. I could speak from the perspective of I've worked with artists who have audited their CMO. So to ensure that they were getting the money that they deserved because of whatever arrangement they had with their CMO, they were able to then audit the CMO, see their records, and so forth and so forth. And that's how the members are able to hold the CMO accountable in some instances that I know of. I don't know of a situation where like somebody who pays then asks that question. I think the arrangement is between the members and the person who they sign up with and who they choose to represent them. And so I wish more creators were here as well. But yeah, I know that is the way that relationship functions in some instances.
I'd just like to add one important thing, that the work has to be in the repertoire. So if you write 1 million songs and you're an ECHO member and you don't register them and put them in the repertoire, you can't get anything. So they have to be registered.
Essentially, there will be no data to match.
Just to affirm what you said that currently you guys do not target anyone. So we've had a series of events for the entire year, every single weekend. Are you saying that you guys write every single promoter to ask them to register or to collect a license or the blanket fees? Or is it just promoters who have overseas artists, or is it just promoters who have what you may consider a large event? What is the threshold? Because technically, what you're saying is your job is to collect from everyone, wherever music is being played. So I just would like for you to affirm whether it is that you're confirming that you guys write everyone. I don't want to use the word target. Do you require this from everyone?
I think I can answer. I think the requirement is that you have to follow the law. It's as simple as that. We shouldn't have to write.
Although we do. We do contact, whether it is face-to-face, a telephone call, or a letter. It happens.
What if the promoter that's having the function is using artists that are not registered, right?
Mm-hmm.
They're using artists that are not registered. Why
Registered
they have to
with any CMO?
with any CMO? Why they have to get a license?
Okay. Let's think 3 years down the line, or up until 3 years down the line. They may not be registered now, but they will be registered maybe a year after or 2 years after. What happens is that we have something called pending identification. So that license fee would sit there for once we have something to match. So, for example, these individuals may say, well, I performed at this event, and I sang these songs. What is in it for me? The first question ECHO would ask if they came to us. Are you registered with any CMO? If they say no, we will tell them then you have a certain amount of time to register with the CMO, and then you can gain your royalties from that. So it's as simple as that.
And that's the international standard. All CMOs do that.
Mm-hmm.
Just to ask a question. I manage a couple artists right now. Both are registered with ECHO. They are required to submit their performance agendas.
Yes.
So once an event is, so it's required before or after the event?
Before or after?
Okay.
Because, they may ask for you to come back on for an extra 2 minutes, 5 minutes.
Okay.
Yes. But I need to stress as well that a lot of we have had questions where persons would come and ask for royalties, and when they name out the events that they've performed at, they were not licensed. So basically, you can't expect to get a return from something that we didn't receive.
So I think there definitely needs to be that collaboration between ECHO and the authorities to ensure, like in other islands, when you are getting a license to host an event, that you have covered your ECHO fees, you have covered your...
Yes, MASCRO guidelines is something that is standard, and we have already, we've mentioned it as Ms. Williams spoke about earlier. We had meetings with the Attorney General and the Commissioner at the time. Previously, yes. So we're hoping that there's a change coming. I think the change is happening, actually.
All right. Well, based on what was just mentioned, I feel as if authorities, ECHO, and stakeholders should all be in the same room. Definitely. Grace mentioned it is law that every event organizer gets a blanket license.
The license to use the works.
The term, okay.
Mm-hmm.
How do you determine who to pursue? Since, based on what you're saying, nobody taking it.
I'm not sure. Can you elaborate a bit on the question? What do you mean, who to pursue?
Who do you pursue legally, since they are breaking the law? How do you determine who to pursue legally? The police don't pursue nobody.
I answered that in another forum before. I answer it again. Every agent, it doesn't have to be an ECHO agent. Every agent in every part of the world, there's somebody who does a job like mine. They're on the ground, and they're responsible for monitoring all the use of music on the ground. They're responsible for contacting users, and they're responsible for licensing. Now there's a process, and our director spoke a bit about the process. You take the time and you contact the users over and over and over. You can't just go to a user one time and say, give me the money. That's not how it's done. You have to have a record of the user being contacted over an extended amount of time before you take any kind of action. That's how it works. Not only for ECHO, but every single CMO or PRO. That's how it works.
If I am the owner of a venue, that one of these entertainment, one of these big event is being hosted, is it, am I supposed to be asking the promoter if he has a license from ECHO?
Law speaks to that.
I don't know if this, yes. The law actually says that if you are the owner of an establishment where copyright is being infringed, you could also face liability as well. Wow. So it's important that owners of establishments where music is being played in public, that they ensure that the promoters or the DJs or whoever is playing music also is covered to protect themselves, because the owner of the establishment, not only the owner of the establishment, but the owner of the equipment that is being used as well, could also face liability.
Okay, second part of my question. I'm the managing director of Freaky Bay Development Corporation, and from time to time, functions are held on the beach. Now, part of what is mandated to me is that they have to write for permission to have a function on the beach. Obviously, they'll have to get permission from the police. Now, the beach, although it being government property, public, well, government is public, right? As the person, well, Freaky Bay, I'm the one writing the letter to the entertainers, well, to the promoter saying, yes, you can use the beach for your function. The property belongs to the government, the beach. I am only the one saying, I'm giving you permission because I want to make sure that you keep the environment, or you leave the environment as you meet it. Take up the garbage, don't destroy this. Do I need to know that he has a license to come on the beach?
To protect yourself, it's best if you also
You sound like
know that
Grace.
as well. Well, I'm telling you what that's what the law says. That's what the law says. And bear in mind, saying that it's government, you know, saying that it's government property. Government is not exempt. Government is a user as well, who would still also have to be subject to licensing fees, which is why Carnival Committee is here, and we extended the invitation to Music Festival and other government departments as well. Their government is also subject to the same requirements under the law.
So this also extends to persons using the lawn, because from time to time people write in they're having a little family function on the lawn and they're going to be playing some music from a little radio.
Playing music in public, there is no threshold. There is no threshold in terms of we exempt 4 people, a family of 4, as opposed to an event of 4,000.
So if Grace drives by the lawn and sees somebody there, a family of 10 having some music, she come after me because they don't have a license?
You say come after. I'm just going to advise you. Didn't I advise you? That's what I did. Yeah. Keep trying to keep you out of trouble.
Yes.
Is there like a blanket umbrella policy that, let's say, for National Carnival, you have 30 registered event promoters, and these all fall under the National Carnival official events, private events that fall under National Carnival. Do each one of those event promoters have to separately apply, or is there like an umbrella?
So it's not like a fringe. It's not like a fringe event. It's not
Well,
like a separate.
I like to call it private event. It's a private event. It's not an official National Carnival event, but they make up, these events all make up National Carnival. Is there an umbrella policy that National Carnival can have that all of these event promoters fall under?
That is a technical one, because
it's also maybe
is
an
Carnival going
expensive
to accept
undertaking.
the liability for all of the use of the music? That's the key issue. And if Carnival is, then Carnival has to pay for everything. Will Carnival pay for everything? That's the issue.
And Carnival would have to assist ECHO in finding
Music
out,
license.
yeah, you know, how many individuals are going to be at these events, etc., etc.
Right.
So from an administrative standpoint for Carnival, you'd have to be prepared for that as well.
So the easiest thing I would suggest is to at least inform all of your private event promoters that they have a responsibility under the law that they will be responsible for. That would be my advice.
Like I said, we have an introductory rate to the tariff, so it should be presented anytime soon. If we don't have any other questions, I'd like to let the representatives do this, because it's already...
This from St. Lucia, and they're at the headquarters. We forgot to mention that our headquarters is actually in St. Lucia. So we operate throughout the Eastern Caribbean, and also we're responsible for Anguilla, Montserrat, and the BVI, but our headquarters is in St. Lucia. So we have two persons from St. Lucia who are going to speak. The majority of the presentation will be done by the licensing support officer, Ms. Vindra Casabon. They're there.
Good evening, ladies and gentlemen.
Good evening, everyone.
We can hear you.
We're hearing you. Okay, my name is Vindra Casabon, and I'm the licensing support officer of ECHO. I'm here with Mr. King Quarter, who is the officer in charge / membership officer. It's a pleasure to be here today to present on the ECHO tariff as well as the licensing introductory rates. And towards the end of the presentation, my colleague, Mr. Porter, will present a bit on the membership side of things. Okay? So we welcome any questions that you may have that you may need answered towards the end of the presentation or even throughout. Okay? Just allow me to pull up my presentation. Okay. What's happening? Okay, so the licensing introductory rate arose from an initial meeting held in St. Kitts on Thursday, 6 October 2022 between Ms. Venaldarin Francis, who is the ECHO Director, Ms. Grace Richardson, who is the ECHO Licensing Agent, Ms. Gian Williams, who is the IP Registrar, and Honorable Gareth Wilkin, who is the Attorney General. This meeting was necessary to come to an amicable agreement between ECHO and the government, music creators and music users of St. Kitts and Nevis in the area of licensing and compliance of music rights. The Eastern Caribbean Collective Organization for Music Rights, ECHO Inc., is a non-profit association of songwriters and publishers of music and is the legal entity responsible for administering the performing rights of its members and members of affiliated societies such as COSCAP in Barbados, JCAP in Jamaica, CORT in Trinidad and Tobago, ASCAP, BMI and CISAC in the US, SOCAN in Canada, etc. within the OECS. Through reciprocal agreements, ECHO has control of the world's repertoire. That is to say, we are responsible for licensing all public use of music in the Eastern Caribbean, irrespective of which country the songwriter is from. At the meeting, ECHO agreed to introduce a reasonable licensing rate to the music users of St. Kitts and Nevis in an effort to increase the level of compliance and the licensing revenue in the territory. The introductory rate does not constitute a change in ECHO's existing tariffs, as our tariffs and that of members of the Association of Caribbean Copyright Societies Access are governed by Access, which develops regional standards on the governance of CMOs and operational matters, such as establishing licensing practices. The introductory rates will take effect from today, the 1st of November 2020, and will run for a period of 1 year. The main objectives are as follows. 1, to educate music creators, and music users on the importance of music rights. 2, to license all music users, that includes broadcasters, hotels, guest houses, restaurants, bars, shops, stores, banks, offices, event promoters, etc., thus increase ECHO's licensing revenue. And 3, to foster a partnership with the government, IP Registrar's Office, and other creatives in St. Kitts and Nevis. For the stakeholders, ECHO plans to license all music users in St. Kitts and Nevis. Therefore, all business owners, broadcasters, and event promoters will be contacted for a license. The licensing terms. Okay, so the terms outlined here are just a few terms that would be mentioned in the latter part of the presentation. So this is just to give a brief description of what each term is. So public performance is one that occurs either in a public place or any place where people gather other than a small circle of family or its social acquaintances. A public performance is also one that is transmitted to the public, for example, radio or television broadcasts, music on hold, cable television, and by the internet. A public performance license. A public performance license is an agreement between a music user and the owner of a copyrighted composition or a song that grants permission to play the song in public, online, or on radio. Mechanical license. A mechanical license is an agreement between a music user and the owner of a copyrighted composition or a song that grants permission to release the song in an audio-only format, interactive audio streams, digital downloads, CDs, or vinyls. This permission is also called mechanical rights. A synchronization license. A sync license is an agreement between a music user and the owner of a copyrighted composition or song that grants permission to release the song in a video format. That includes YouTube, DVDs, Blu-rays, discs, etc. This permission is also called synchronization rights, sync rights, or sync rights. Reproduction fee. A reproduction fee is the cost associated with copying the content from one medium to another, for example, from the computer to a website. and making it available to the end user or public. Okay. So in this part of the presentation is where we would introduce our licensing rates. Okay, so we'll start with the broadcasters. ECHO's tariff for broadcasters are calculated as a percentage of the gross advertising revenue, in addition to the reproduction fee as outlined in the table below. So the broadcasters would be cable, radio, and television. These are the three broadcasters that ECHO collects license fees from, sorry. So for cable, we charge 1.625% of the gross advertising revenue. For radio, it's 2.5%, and television, it's 1.625%. In addition to that, there is a reproduction fee, of 10,000 for cable, 3,000 for radio, and 6,000 for television. ECHO will introduce a 50% reduction in the reproduction fee, which would be appropriated as follows. So for cable, as opposed to paying 10,000 for the reproduction, it will be reduced to 5,000. Radio will be reduced to $1,500, and television will be reduced to 3,000. Broadcasters also have the option of submitting monthly logs to ECHO in Excel format, or ECHO can digitally monitor their frequency through BMAT for an annual fee of EC $1,000. So in Director Francis's presentation, she mentioned what BMAT is, which is our online monitoring system. Okay, so if the broadcaster feels like it's probably a tedious task for them to provide the logs, then they also have the option of having ECHO, take on the task by paying an annual fee of $1,000. Are there any questions at this point? Okay, so concerts and events. The image below is an extract of ECHO's current concerts and events tariff. So the scope of tariff, meaning what it covers. The tariff applies to the performances of specially featured entertainment, whether by live or recorded means, at concerts, fests, dubs, shows, festivals, celebrations, and other similar events where there is a charge for admission. 1.2. Excluded from this tariff are performances of featured music at carnival events. So there is a special tariff for carnival. This tariff will not apply to carnival. This tariff applies to the copyrights in the musical work, positions of composers, authors, and publishers. Okay, so the royalties as a percentage of gross paid receipts, as defined in 2.5.1 above, is 5%. Yeah, so okay, Is better? Okay. So the royalties as a percentage, of the gross gate receipts, as defined in 2.5.1 above, is 5%. So ECHO charges 5% of the gross gate receipts for events. Want a figure? little more. That's good. Okay. So in the event that the event is a free event, we go based on the capacity. So where you have an event which with 500 persons and less, we charge $400. 501 to 1,000, 815, and so on. In addition to that, if your event is a semi-inclusive event, then there is a 30% reduction in the total licenses fees due for the event. If it is a all-inclusive event, there is a 50% reduction in the license fees, due for the event. Okay. So, ECHO will introduce a 4% rate of the gross receipts to event promoters. For free events, we will offer a 10% discount on the rate as per the capacity. So, going back to our tariff, instead of charging the 5% of your gross receipts, we will introduce a 4%. And if it is a free event, then we would go based on the capacity. However, we will provide you with a 10% discount. So, for example, if your event is a free event and you cater for 500 persons, it would be $400 less 10%. Okay. So note, this discount is not applicable to the minimum daily rates for back it's $150, for specially featured or live music it's $400. Okay, so this is the Carnival tariff, Carnival Street Parade. The image below is ECHO's current Carnival Street Parade tariff. The scope of tariff, 1.1, this tariff applies to the performance of specially featured entertainment on the road during Carnival, whether by live or recorded means. The tariff applies to the copyright in the musical work of composers, authors, and publishers. So the royalty rate is calculated as follows. We charge $2.50 per regular per day for our Carnival Street Parade tariff. ECHO will introduce a $1 fee per day per regular. That includes Parade of the Bands, meaning the 2-day parade, Kids Carnival, and T-shirt bands. Okay. Moving on to restaurants, bars, and cafes. Okay, so the image below is an extract of ECHO's current restaurant, bars, and cafes tariff. This tariff applies to the performance of background music in restaurants, fast food outlets, lounges, bars, and similar premises. This tariff applies to the copyright in the musical works of composers, authors, and publishers. So the tariff is as follows. We charge the annual royalty per room for performances by radio CD player is, we charge $376 for the first 15 seats. Each additional 10 seats or part thereof is $74. In addition to that, if you decide to have probably a guitarist or a form of live performance or live entertainment at your business, we charge 5% of the expenditure on entertainment for the year. All the above is subject to a minimum annual royalty of $376. Where the sole mean of performance on the licensed premises is a rum shop, we charge $218. Okay, moving on to the next tariff, which is karaoke. The image below is an extract of ECHO's current karaoke tariff. This tariff applies to performances of music by karaoke bars, or other establishments operating in a comparable manner, including on coastal vessels, for performance by the proprietors of the premises. The tariff applies to the copyright in the musical works of composers, authors, and publishers. The royalty rates for karaoke sound systems, and the annual rate for karaoke sound system is $450. For each additional operator, it's $225. For single events karaoke, it's $150. For the first 100 persons, each additional 50 persons or part thereof is $20. All the above is subject to a minimum daily royalty of $150. Okay. So the annual license fee for restaurants, bars, and cafes is solely based on the seating capacity of the venue. The annual license fee for karaoke is $450. Restaurants, bars, and cafe owners sometimes request a copyright music license which incorporates karaoke and or specially featured music. In such cases, the restaurants, bars, and cafes, as well as the karaoke and or specially featured music tariff is applicable. We propose the following rates, the following introductory rates. Restaurants and bars, for the first 15 seats, we propose $300. Each additional 10 seats or part thereof is $70. For karaoke, the annual fee would be $400 and the daily fee would be $125. For specially featured music, the royalties payable as a percentage of expenditure on entertainment is 4%. In addition to that, we will also introduce a free month payment plan on the annual license fee. Okay, so we have a few examples here where each tariff would apply. So 6 music users applied for licenses from ECHO for different music uses. Using ECHO's current restaurants, bars, and cafes, karaoke, and specially featured music tariff, the license fees would be as follows. Vibes Bar and Grill, 15 seats with background music only would be $376. The Spots, 20 seats, background music only would be $450. Now the reason it's $450 is because we charge $376 for the first 15 seats, and each additional 10 seats or part thereof is $74. So considering that they have 20 seats, the first 15 seats would be $376, and the additional 5 seats would be considered part thereof, which are $74. So that brings us to a total of $450. Jay's Restaurant and Bar have 12 seats, and they have background music and karaoke. Now, $376 would be for the first 15 seats, and of course, 12 would be considered 15 since it's the first 15 seats. And karaoke for the year is $450. So the total of $376 and $450 would be $826. Relax Cafe has 25 seats with background music and karaoke. So that would be $376 for the first 15 seats, and the additional 10 seats would be $74, in addition to the $450 for karaoke, which brings us to a total of $900. Biz Lounge has 12 seats with background music only. However, they have a live entertainment feature at the business. So the annual fee for that live entertainment feature is $2,000. So it would be 5% of the $2,000, which is $100, plus the the 12 seats, which would be $376, which brings us to a total of 476. The lawn has 17 seats with background music and karaoke, as well as a live entertainment feature. They pay $4,000 or allocate $4,000 to annually. So it would be the 5% of the 4,000 plus the 300 and the first 15 seats, which is the 376, plus the additional seats, which is $74, in addition to the 450 for karaoke, which brings us to a total of $1,100. Using the introductory rates, the license fees would be reduced to: for Vibes Bar and Grill, $300, The Spot, $370, Jay's Restaurant and Bar, $700, Vase Lounge, $380, Relax Cafe, $770, Vase Lounge, $380, and The Lawn, $830. With rum shops, small rum shops not exceeding 300 square feet would be $200 annually. Okay, banks, offices, and industrial premises. Yes. This tariff applies to background performances of music in offices, banks, and other similar premises. Excluded from this tariff are background performances of music in waiting rooms, in doctors' and dentists' offices, hairdressing salons, and barber shops. To such premises, the appropriate tariff usually should apply. Okay, so the rates are as follows. We would charge $1,280 for the first 25 units of employees, in addition to a fee for the square footage audible to members of the public. The introductory rate will be calculated on the total square footage of the premises, and a 3-month payment plan will be implemented. Shops and stores. The image below is an extract of ECHO's current shops and stores tariff. The tariff applies to background performances of music in shops, stores, shopping complexes, kiosks, showroom, and other similar premises. Excluded from this tariff are background performances of music in restaurants, cafes, lounges, included in or attached to shops and stores. To such premises, the appropriate tariff, restaurants and bars, should be applied. So for shops and stores, we go based on the square footage of the premises. The tariff for shops and stores is based on the square footage of the premises. We propose the following. Shop space up to 500 square feet would be charged at $250 per annum, and those that are 501 square feet and over will be issued a 15% discount with a 3-month payment plan. For community minimas not exceeding 500 square feet, the annual fee is $200. Online music use. The image below is an extract of ECHO's online music use tariff. This tariff applies to works communicated or transmitted from or through the website, to the copying of a sound recording of a repertoire work on a computer files server for the purpose of transmitting the same to private individuals from or through the website. So for streaming, there is a quarterly reproduction fee of $500, which brings it to a total of $2,000 for the year. In addition to that, for communication to the public, there is a 2.5% royalty charge per quarter. For non-profit operations, Reproduction and communication to the public is the same $500 per quarter, which brings you to a total of $2,000 per year. And all of the above is subject to a minimum annual royalty of $2,000. Okay, so the four online music streaming services outlined here are services that some of which ECHO has licenses with. For example, Facebook, Spotify, and YouTube. Facebook and Spotify, sorry. And Apple Music. So at this point of the presentation, Director Francis, Agent Richardson, as well as Mr. Potter will provide you with a little more insights on the licensing of those online platforms.
To Sonos, we have noticed that there are establishments using Sonos speakers in their business, and what we did was to do a check, because basically if you're going to use content through Sonos speakers in the Eastern Caribbean, you have to have a license for business. So we checked with Sonos, and we also checked with some of those US CMOS PROs to find out if they had any kind of agreement with Sonos for users to use music in their business in this region. So far, no go. So our Caribbean societies, we know for sure, we don't give that permission, and the ones in the US for sure, they don't give that permission either. So we have not been able to find any CMO or PRO that has given permission for the use of music business. There are arrangements in other parts of the world where Sonos has agreements for their music to be, their speakers to be used in business to stream music, but not in the Eastern Caribbean. So as far as we know, as far as we are aware, anybody who is using Sonos speakers at the moment and they're using music, that is not supposed to be done without getting a license to operate in the Eastern Caribbean.
We're running out of time, so we're trying to wrap up here. Okay, as it relates to YouTube, we've been asked questions about whether an entity or a business could use YouTube and play it, and saying that because it's YouTube that they don't have to obtain the license. Now, based on how YouTube operates, it has the view, per view system in place. So if I have a channel, for example, or say Chanel has a channel on YouTube, and she has some music on there, every time an individual goes to that channel and they play her song, she gets one view. Now, if I have a business and I play her song from YouTube at my business place, it's going to show up as one view. But yet my business place may have 50 individuals. Now, Chanel is not going to benefit from those views. She wouldn't get subscribers because of it, et cetera, et cetera. So essentially, it is illegal to have your YouTube being played for numerous individuals without obtaining a license. So to cover yourselves, it is important to do so, to obtain the license so that you are not liable. Yes, I think Mr. Cotton and Ms. Casabon had one more thing, but we're running out of time. So what we will do is that we'll make the tariff document available to you guys, to everyone in the room. And if there are any questions at this point, we can take 5 minutes, because we need to wrap up and leave for 8 o'clock. We have to be out before 8. So, by 8?
Or we get charged.
All right. So if there are any other questions, we'll be happy ECHO or the IP office would be happy to answer. What am I?
You said just now that the tariff will be given to those in the room. Is there a register being taken? And what about those persons online? Won't they want to read the tariff thingy too? Is it possible to just make it public so that everybody just informed and everybody know what is what?
Let's just say that making it public on the website may be a little bit ticklish for us. We can work something out. And as it relates to having the register, I was hoping that those who are interested in seeing the document, they will come to us and we can take the information and we can forward it. Okay, yes. So we'll make it public as well, okay? But if you needed to have it, like right now, before we publish it on the website, you can put your name and email address down on that paper by Ms. Williams, and we'll send it to you. Any other question?
Just a comment to let you know that, remember, this is not all. There are more tariffs. So we didn't speak about the ones for hotels, right? So there are more tariffs. So just contact us and we'll be able to give you more information. Okay, so our website is echorights.com or .org. When you click on the flags at the bottom, the St. Kitts flag on the website, my information will come up. My email address and also my telephone number will come up. It's on the site. The tariff documents are on the site. If you go and type and click the section that says music user, you will see the option to choose the tariffs so you can see the tariffs. All the tariffs are on the site. And as our director said, we're going to put up the introductory tariff on the site.
Note that we are doing this introductory rate in St. Kitts and Nevis first, and the other territories have not, we haven't had the discussions yet with their government, so in relation to this introductory rate, so that is why we have to, I can't say for certain when, but it will be made available online soon. Our director is vfrancis@echorights.com or .org. Shall I give your telephone number? It's on the website as well, as far as I know. No, my number is not on the website.
Oh, sorry. So
your number is?
It's 762-1117.
763-1117.
Sorry, 763 minus 2. Oh gosh, poor me.
Grace is 762-7139.
Okay. It's on the site, they'll find it. And our office persons, their contact is on the website. If you don't want to deal with me, you can always deal with Ms. Kazaban, because she does licensing as well, right? So you can either deal with the head office or you can deal with me, right? Okay.
Sorry, one more comment than a question. Mike. One thing that I've noticed is that it's more of a blanketing than specifics. I think what you guys should do is separate stakeholders by type and categorize them in groups so that they can ask questions that are more specific to them. You can give them more details, because I think after a while some people would have probably stopped listening because certain things weren't related to them.
I just want to say I agree with that 100%. In addition to that, I feel as if, based on what Shannon mentioned and myself, there should be the IP office, ECHO, and authorities. When I say authorities, I'm speaking about, well, as I mentioned, police. We should all sit in a room and have further discussions such as these. I don't think it should just be a one-time thing and then we just run into paying fees.
So that's actually the plan for us to have. We've made the recommendation to the Ministry of the Creative Economy to have a forum on entertainment and the creative economy so that people can air their views. We're hearing recommendations that people want to be more aware that they have these responsibilities. And as far as we're concerned from the IP office, I think that's something that we can push for. And hopefully we'll have more success because this is something that we've not just been trying to do this today. This is years, at least 5 years in the making and attempts, but today was the first time that we decided to focus on event promoters and radio stations and things of that nature. So this is just the beginning because we want to encourage compliance with the law and of course to give people a chance to get more specific information now that you've been introduced to it. I would really encourage you to reach out to ECHO to find out what your specific responsibilities would be. This is just an introduction and we will continue as necessary. Any other questions? Okay, so thank you very much for coming. We heard the recommendations, we appreciate the questions, we appreciate your presence, and hopefully when you see more conversations happening on social media about ECHO and licensing, that you have a clearer understanding of what should happen and what could happen. But this is just the beginning and we're just hoping that you all benefited from the information, and I encourage you to reach out to us at the IP office. Our office is located in the former CNC supermarket building upstairs, or you can check us at our website www.ipo.gov.kn. So thank you so much for coming. Unfortunately, we don't have snacks because it pays to stream and get a venue and all of that stuff. It's more important that we stream it than to feed you. So I hope you could appreciate that. So thank you for coming. Thank you, ZIZ. Thank you, Nemo. Thank you to the Ministry of the Creative Economy. Have a good night. Get home safely.
Thanks for having us.
Okay.